Good morning. My name is Sarah Fossholtz. I serve as the Board Administrator for the Texas State Board of Examiners of Marriage and Family Therapists. I'd like to call the roll. Dr. Merchant.
Present.
Dr. Barty.
Present.
Dr. Elder.
Present.
Mr. Francis. Mrs. Husband Thompson. Mr. Parrish. Pastor Skoma.
Present.
Ms. Smith. Chaplain Stodlin. I show Chaplain Stodlin is here.
He appears to be muted.
Appears to be muted. Okay, so we do have five board members. We do have a quorum. I'd like to announce that the presiding officer this morning is Reverend Dr. Skoma here in the building with me at the public location. And we're ready to proceed. Vice Chair Skoma.
Thank you, Ms. Fossholtz. It being Friday, January 21st, I show 9:07 a.m. Call to order this meeting of the Texas State Board of Examiners of Marriage and Family Therapists. Let's move on to agenda item number 2. Has everyone had a chance to review the minutes from our October 22nd, 2021 meeting?
I had a report of a couple of typos in 11A and 11B on the minutes. It reads Dr. Merchant Professional Development Committee. It should be Dr. Merchant requested. I'll make that change if that's all right with the board members.
Thank you.
I move that the minutes be accepted as amended.
Second.
Okay. Does anyone have any questions, further discussion at this time? Okay, that being the case, those in favor of accepting the minutes with the changes that Sarah has mentioned, please indicate by raising your hand. Appears to be unanimous. So we will move on to agenda item 2, board review and possible action regarding appeal of application for licensure denials.
And there are no cases to review.
I understand there are no cases, so we can move on to agenda item number 4, board review and possible action regarding agreed orders to be executed by the board. Is that also?
There are none to be reviewed by the board.
Thank you. At this rate, we'll get through. Item number 5, board review and possible action regarding contested cases from the State Office of Administrative Hearings. Do we have any SOA hearings?
I know of
This
none.
time?
The attorneys are shaking their heads.
Thank you, gentlemen. Moving on then to agenda item number 6, report of agreed orders executed by the council's executive director. Is there any discussion on this?
That was in your board materials.
6. Uh-oh. I just noticed this opens on this, so I lose my.
Oh,
Sorry. That's okay. Get back to. Apologize. I'm working on a state computer that I haven't worked with before, so I'll get the bugs worked out. I'm a graduate of the University of Texas. I should be able to figure out how 2 windows work on a PC. Okay. Any discussion on this matter?
We need to make a motion that we just accept the report as written.
So I'd like to make a motion, or would anyone like to make a motion that we accept this report as written?
I so move, Mr. Chair.
I second.
That being the case, any discussion on this issue, questions, discussion? Okay. Those in favor of accepting this case as offered to us? Raise your hand. Okay, being 5 in favor, the motion carries. So we move on to agenda item number 7, report of cases dismissed by the council's executive director. Can you get that report?
I have a question about that report. And I think maybe we talked about this last time and maybe I've just forgotten, but can I get some clarity or like under what case would we dismiss something with insufficient evidence? And the reason I ask is just there's a lot of them that get dismissed with insufficient evidence. And I would just imagine as a public member, if I were seeing just a member of the public, if I were seeing all these, I might wonder if, is the board really taking these complaints seriously? Are they, just trying to, they don't want to tarnish the image of their therapist. You know what I mean? Like I would just, as a public member of the public, I might just have questions about that. So I'm wondering if y'all could offer us some clarification about, like, just
What does that mean?
what does that mean?
Yeah, sure. If I can try to address that as best as possible. Typically what that means is a complaint came in, staff looked at it, identified possible violations, sent the complaint to the licensee for a response and gathered information and a response from them. And then they may throughout the process reach back out to either the complainant or the respondent licensee and gather further information. But through that whole process, it'll either there won't be an ISC or there may be an ISC that'll review it. But at any point during that, they'll look at it and say, look, there may have been a complaint here, but we don't have enough evidence to prove that this particular conduct that's complained about actually occurred. Whether it's we don't have enough witnesses, documentation, it's an allegation, but we would need at least sufficient proof if we were to move it on to the next step to SOA, if it were to get appealed, in order to prove it in a legal context. And so in order to get dismissed from that, it has to go through a staff investigator, and the investigator has to say insufficient, we don't have enough evidence to prove it. Then it goes to a staff attorney, and then the staff attorney says there's not enough evidence to prove this. And then it goes to the executive director, and the executive director says we don't have enough evidence to prove anything. So it goes through many checks and balances before it doesn't get just summarily dismissed. It goes through a lengthy process of review to go through that dismissal process. But the insufficient evidence, the description there is sort of that. It is a bit of a broad description, and I get why you look at that. But the problem is while yours might it looks long to me, but the other boards are much longer, and so it's impossible to put enough so much detail that we kind of created sort of categories to say we don't have jurisdiction over this person, or that we can't prove this particular thing. The other issue too to point out is if it's insufficient evidence, that person that filed the complaint can always file the complaint with us again if there's new evidence. So if they say we can't locate these witnesses that you say that saw this conduct, we've called, we've sent letters, we can't get them, we have to dismiss this for lack of evidence. If they say, oh no, I know where they are, they were out of the country, they're back here they are, they give us new, we can reopen the complaint. We just won't reopen the complaint unless there is new evidence, because we're not going to go through the same thing all over again, looking at the exact same stuff. So does that answer your question?
Guys, and so I guess the thing that reassures me is it sounds like there's at least 3 different sets of eyes on this that make this determination that there is insufficient evidence.
Yeah, and that's written out in the BHEC rules for the process for a dismissal. So that, yeah. Okay.
The other thing is, could you give me maybe an example of what, like, would it be like a he said, she said type situation, or like a
Sure, like an example of something. So what might be is they'll say, I've heard this licensee has done this sort of conduct, and we'll say, okay, well, we need somebody who can actually, have firsthand knowledge, who can testify that it may not be necessarily the victim that had something happen to them. And so we may try to reach out to that victim and see if they want to join in part of the complaint, they want to be a witness, if they want to file their own complaint. But we can't take a third party's testimony that says my brother's nephew's sister's cousin's uncle told me that this guy did this bad stuff. That's not only will that get kicked out of SOA, the agency will end up getting fined and have to pay, fees for taking frivolous claims to court. So
okay. Cool. Thank you very much. That's very helpful.
Thank you, Councilor Hyde. Are there any other questions about cases in number 7? And we don't have to vote on that, do we? We just receive the report and move on. Okay. Looks like we're ready to move on then to Agenda item number 8, which is the status report of quarterly enforcement case activities. You have that report in your information.
I just want to comment on how much progress y'all have made, and just, I am so pleased by these numbers, and y'all have just worked so hard. I don't know, just excellent work.
Thank you.
I was a history major, and even I could do the math on this. That's really good progress. So well done. Okay. Anybody else? Discussions? All right, then, hearing none, we'll move on to agenda item number 9, a report of compliance with agreed orders. Do we have any reports?
That's in your meeting materials.
Okay.
So only if
Oh,
the
yes.
board members have questions.
Okay. Anyone? Okay. Take that silence as approval. And move on to number 10, the report of the committee chairs. The first report would be that of the Ethics Committee, chaired by myself. All of our licensees are being very ethical, because we did not meet in this last quarter and don't appear to have any issues at the moment. So that's good. So I'll pass it on to Dr. Merchant and her report on the Licensing Standards Committee.
Yeah, okay, so Licensing Standards Committee, we met in early November. We talked about a couple of things. The first thing we talked about was just the Continuing Education Standardization Committee. The BHEC Standardization Committee was meeting, and they were talking about continuing education. So we met with Ms. Smith about just trying to give her some feedback. So we did that. We also had a conversation about kind of something that came up in the October meeting, was supervisors moving into Texas, like from out of state, and making sure that they are familiar with the Texas rules. And so did we want, do we need to do more to make sure that they are aware of the Texas rules? But the thing is when they transfer their license to Texas, they have to take the jurisprudence exam. And then presently, at least, to renew your supervisor's license, you have to take the jurisprudence exam every time you renew. And so because of that, we just didn't feel like we needed to go above and beyond to do something additional, since they are taking the jurisprudence exam. And then finally, we also had a brief conversation about, just kind of given COVID and the increase in crisis management. We also talked about, like, as Pastor Skoma, or as Chaplain Skoma, oh my gosh, I'm just confusing names here. Chaplain Stoglin, there we go, Chaplain Stoglin. As he had mentioned about like working with military families and just kind of some of the crisis there, we kind of had this conversation about, do we need to adjust our academic requirements, or do we need to make a CEU recommendation to kind of, focus on these two areas? And we decided right now to kind of table it, that we can readdress this in our 4-year rule review, which is coming out in 2024. There also might be some additional legislation about crisis management. And so we thought maybe we would kind of hold off and kind of see what the legislature decides to do about that. So any questions about our conversation? Yes, Jody.
I have a quick question. So I absolutely wholeheartedly agree with the decision about crisis management and military. I mean, there's so much coming down the pike with that I think action right now would be a little premature. But I also wanted to ask, there is and maybe this is more appropriate for our conversation, for the BHEC standardization standards for CEs that came out. But one of the things that I think was mentioned last time, and I'm wondering if y'all discussed or had any thoughts about it, was possibly requiring part of our ethics to specifically address Texas ethics like the LPC board has. Is that going away through the BHEC standardization, or is that anything that y'all discussed for LMFT?
We did not discuss that. So what do you mean, like Texas ethics?
Are you referring to academic requirements?
No, it's my understanding, and I mean, maybe I'm wrong, but for LPCs, you have to have a specific number of hours of your CEs that address ethics, just like we do. But out of that ethics, a specific portion of it has to address Texas rules and statutes. And you have to, like, when we go to TCA conferences, we're like, okay, which ethics programs cover Texas so we can get those CEs. So I'm just wondering, it's just a way to make sure people not only know, like, large, very broad decision-making models for ethical situations, but also the Texas rules.
Yeah, that did not come up in our conversation. I don't know if, given the standardization committee's work, I don't know if that would be something we would want to consider or not. Daryl, you're unmuted. Do you have a comment?
Yeah, the LPC rules don't require continuing education specific to Texas ethics. They just have an ethics requirement. Now there are some coursework requirements that require Texas specific the way it's done right now.
Okay.
But I'll tell you, that's causing problems on the LPC side. So I would not recommend y'all go that way, because we had a meeting yesterday with the LPC Rules Committee to talk about that exact issue, among a few other things. So that's.
Can you give us a report on how that conversation went?
Yeah, not good.
Okay.
They've got some academic requirements. They made some changes, I don't know, 9-10 years ago, that kicked in about 4 or 5 years ago. And now they have 2 coursework requirements that are basically the same course. So they're requiring folks who come in under what they call a counseling related degree. An MFT degree would be a counseling related degree. They require those folks to have both a psychopathology, and that an abnormal human behavior. You have to have both those courses when most people only have one, because it's, in my layman's understanding, it's the same thing. We used to treat it as a synonymous terms. One of them is just a more modern term than the other. So that's a problem for them under the LPC board. And then they've got professional orientation and ethics requirements. And those are apparently 2 different things. Professional orientation is geared more towards identification as a counseling profession, and then ethics is more of your ethics requiremets here in Texas. So that's kind of how they view it. It's not really, they don't really say Texas ethics, I don't think, in their rule, if I'm remembering right. But that's how they kind of view it. And I just be careful going down that route, because we've already seen the problems it's caused them, and they're going to have to deal with that.
Right. And that is what Sarah is pointing out, is exactly what I was talking about. And I was asking because I was wondering if we had considered it, because I too think it's very complicated to tailor an ethics presentation specifically to that. And I also believe the JP exam takes care of that. I mean, if we felt very strongly about people knowing Texas rules, we could just require JP exam across the board for license renewal every time. So I think that is an option, the better option, instead of requiring specific CEs in Texas ethics. Thank you for bringing that up. I'm sorry to complicate things.
I'll tell you, the standardization committee did move away from that. Sarah's right, that I didn't even remember that being in there, but yeah, that is not in the standardized rule that you're going to see coming before all the boards. So trying to move away from that stuff.
Thank you.
Dr. March, anything else on the licensing committee?
No, I think that's it. Any other questions about the licensing standards committee and our work? Okay.
Thank you for that report. And by the way, Chaplain Scogg and I both have the gray mustache, so it's very easy to stay.
Confused, yes.
Moving on, but staying with Dr. Marchant, would you like to go ahead and give us the report on the outreach committee?
Yes. So we met actually earlier this month in January. So back in October, at our October meeting, Ms. Smith had proposed maybe us putting together some sort of pamphlet to educate consumers about the differences between like therapy and life coaching. And so we met to discuss this and how basically we could maybe increase therapist awareness of the rules, as well as consumer awareness of their rights. And so one of the things that we proposed was, maybe the problem with the pamphlet is it's going to cost money, and how do you get it out to people? And there's just too many logistics wrong with that. So we thought maybe kind of how we are making these other guidelines, maybe we could make a guideline for consumers that we could just publish on the webpage that would maybe just kind of talk about the different professions and how to pick out a therapist and maybe the differences between, life coaching and therapy. And anyway, so we are gonna, I think the committee is gonna kind of work on maybe putting something together for that. We also proposed creating a standard board presentation that we could take to, professional associations, education, training programs, just wherever that, whoever wants, where we want to go, that just kind of talks about what the board, who the board is, what the rules are, how to apply, those kinds of things, these kind of like standard questions that people have. So I already have a presentation that's almost completely built out. And so we'll probably modify that some, and then maybe start reaching out to schools and other associations to see if they'd be interested in having us do some of these presentations, either in person, if we happen to have a committee member who is in that city, or doing them via Zoom. But again, just to kind of increase just therapist awareness of what the rules are and the board is here, as well as maybe hoping to help consumers become more aware of their rights. So any questions about that?
Dr. Merchant, this is Chaplain Stockton. Thank you, Mr. Chair. I think what you've said, Dr. Merchant, is great. And actually circling back what Dr. Elder indicated about Texas, the great state of Texas here. And so I think if you do that, and since I've been on the board, and I know some of you have as well, we've heard people say in conferences or questions when they call in, what does the board do? When can we see the board? Who are these mysterious people and so forth? I think that really will concretize a lot of questions and answers simultaneously. And that way it removes the mysterious cloth off the curtain and people will see that. And I think it will also enhance others who are thinking about, should they get appointed to this board, what some of the expectations are. And in summary, what lawyer Hyde was talking about earlier and all of the process, I didn't want to say anything because it was extensive in his explanation, but he wanted everyone to be clear, that's due process. And you don't want to be accused of something, if somebody accuses you, you have a right to face the accuser. But if it's proven that there is no evidence at that point, then so be it. But that's protecting both the accuser, the accused, and the citizens of the great state of Texas. So I think your outreach, explanation, and process is spot on, and summary. So I think that's a good way to let citizens know, hey, these are how your dollars are being spent. These are the people who are putting these plans together. This is what they're thinking about. And citizens of the great state of Texas, this is what we offer in this state to you.
Yeah.
Thank you.
Thank you.
All right, any other questions on that report? Okay. Moving on, our Professional Development Committee is chaired by Ms. Husband Thompson, who is unable to be with us today. Sarah, I believe you have her report.
So on behalf of Chair Husband Thompson, the Professional Development Committee met on December 9th and reviewed the jurisprudence exam extensively, and heartfelt thanks to Dr. Barty and Dr. Elder for their time and expertise in reviewing all of the jurisprudence exam questions. Their input was invaluable to the committee's efforts. Before convene on December 9th, all the questions were reviewed. Certain questions were discussed by the committee on December 9th, and then after the meeting, a number of questions were reviewed a second time. The result of all of this work is that the committee suggests for this board 35 random VHEC-related questions be removed from the question pool, and 5 mandatory VHEC-related questions be removed from the pool. This maintains 266 random questions with an additional 21 mandatory questions, of which only 1 is VHEC-related. And as before, each examinee receives from that pool 65 total questions for their particular exam. So if the board approves the professional development report, or if in the next agenda item in discussing the jurisprudence exam so instructs, These changes could be sent to the vendor very shortly, and that exam could be updated accordingly as the board determines. That concludes the report.
Is
I
that-
just want to echo Sarah's thanks to Dr. Barty and Dr. Elder. I can't even imagine how many hours it took y'all to read through all those questions. And so thank you both for your work on that. I am very, very pleased. You know, we have had so many complaints about there's too many BHAT questions, there's too many BHAT questions. And so for y'all to be able to kind of narrow it down the way that y'all did and to remove the random ones and the mandatory ones, I cannot tell you how pleased I am with the work that y'all did on this. So thank you very, very much.
I'll just note that we have some discussion and actions on that coming up next.
Can we go ahead and take discussion in that, or can we go ahead and take action on that now, or do we have to wait?
You want to do that, or we don't have Mr. Francis not being here. I'm not sure if there is a rules committee. Do we want to just handle that? And
I can give you a summary of the rules committee if you prefer.
is everybody good with professional development? Ready to move on? We'll come back to that in a moment. But yeah, Sarah, please give us the rules committee
So
summary.
the rules committee met in December. They reviewed the teletherapy and social media guidelines that have been posted on the website for the psychology board and for the LPC board. They also reviewed the AAMFT recently published telecommunications guidelines. I'm not getting the title of it correct. And they recommended the MFT board adopt similar guidelines, and those recommendations were in your packet. They also recommended, they looked at 801.44 P as in Paul and recommended a change to that. And that's also another agenda item, number 15. So no need to take a vote at this time, but that's where it stems from. The Rules Committee discussed that and suggested a change to the board.
Will we have opportunity later on to discuss and vote on the guidelines for social media and for technology assisted services?
I don't think I have those as a separate agenda item.
Okay. I don't remember seeing them as a separate agenda item either. So
I'll ask Attorney Patrick, can the board review that as part of the Rules Committee's report and vote on an up or down vote or a discussion on that, or does it need to be a separate agenda item?
I mean, I think you have them under this, and these are things that are going to be proposed. But before we get to that, I just wanted to mention the one on the guidelines for technology assisted services. That includes the proposed ruling language change that we're going to be discussing, and so I wouldn't advise adopting that just yet until that rule passes, because you're going to have language in a rule that doesn't exist. So you might want to table that. I mean, I guess you could conditionally approve it once that rule passes. It wouldn't make sense to have a guideline that has rule language that's not actually current rule language in it.
Sure.
So, and the only other thing, Sarah, I think I saw is in the guideline, it uses the word patient when we borrowed that language from the psychology board. The rule proposal doesn't have that in there, but we might want to take the word patient out of where it quotes that rule. I think I see it. It says protect patients, clients, research participants. We just might maybe want to take the word patient out of the policy, that particular policy. Does that make sense? It's on page 2.
I hear you, I understand.
Okay, yeah. So I would recommend probably just waiting on that, unless you really wanted to just have it in the back pocket, have it in the back pocket once that rule change goes into effect, and then adopt that policy, if that makes the most sense.
you're saying to hold off, like table this until after the rule has made it through the entire rulemaking process.
Correct. Because it has a quotation from that rule, which I think it's good to do. I just don't think you can quote a rule that until it is effective, right? And then, sorry.
Okay. I think we could, I totally didn't even think about it, but agree with what you're saying. We can't adopt these guidelines that quote a rule that hasn't been adopted yet. So totally makes sense to table those. Would it be appropriate to move forward with the guidelines for using social media, since that doesn't specifically cite that particular rule?
Yeah, I think, I mean, as part of it's my understanding this was to be brought up under this particular agenda item. So I thought it was to be included initially, Sarah. So I thought it was noticed for it to discuss these items. So if you're concerned about a notice issue, you can always repost and have it under a new agenda item. But my understanding is that's what it was, the purpose of it. So I didn't think it was, I thought it was noticed for it, is what I was going to say. But before they vote on it, I do have one comment on that agenda item. But does that answer your question, Sarah? Daryl, if you think I'm wrong, you can certainly say so, but
Understanding.
No, no,
Give it
I think you're right.
okay. You can vote on it is what I'm saying, that guideline.
What comment do you have on that guideline, Patrick?
Oh, on the social media, the use of social media. So most of it is pretty similar. There's some additions, but the one comment I had was the last, or not the last bullet point, but the last bullet point spilling over from page 2, where it says avoid viewing your client's presence on social media unless given consent to view such information. So full disclosure, we discussed this in the committee. I advised not adopting it. They didn't go with my recommendation, but I would just wanted to point it out. Again, I wouldn't recommend including that in this policy. And the reason being is that all of these other bullet points that are on there, they're guidelines to say, if you do this, you're potentially violating a rule, and that can be, you can get in trouble for it. That particular bullet point, it doesn't violate a rule. If they do that, they don't follow that bullet point, they're not violating any rules. And so I don't see any, I don't think it's a good thing to add to the policy, because you're not helping them really. You're telling them to do something that they're not legally obligated or required to do. So, and I guess to give a contrast to this is, while under Chapter 107 of the Family Code, LMFTs can provide forensic child custody evaluations. And as a standard in that, they would need to go gather additional evidence. And, you know, I would think potentially this, if you followed this guideline and you were doing a forensic study, you may not actually be meeting your requirements to gather all the information you need. So I would think following that might get you in trouble, basically, for that sort of evaluation. I don't know if that makes sense, but I'll take questions. But that was the only one that I looked at and I said I just didn't think it was a great one to add to it.
I tend to agree with Patrick on that one. To me, that doesn't feel like a good idea. Telling folks that you can't look at something that's publicly out there. We're not saying, go hack into their Facebook account or anything like that, but if they're putting it out there for the world to see, to tell our folks, well, you got to turn a blind eye to that. You can't look at that unless you go to them and specifically get permission to look at what they've published to the rest of the world. There's just something strange about that. It doesn't sync up with
our reasoning about it when we had this, because we had this exact same debate during the committee meeting. And the thought was that we as clinicians rely on what the client brings into session. We are not allowed to go call their best friend or their spouse and say, is that true? Or are they exaggerating? Or are they not telling me everything? And in some ways, it feels like checking their social media account to verify or find out more information is in that way a violation of their privacy. Like, they can put out whatever they want. It's not my job to go hunt it down and bring it into session and go, well, you say that, but I saw on your social media. I mean, how would we use that information? And is it okay for us to go gather information about clients that they have not willingly provided to us? So in our discussion, we viewed it as a clinical issue about trust and relationship with clients.
Autonomy. If the client hasn't volunteered that information, there seems to be almost like a violation of their autonomy.
So I thought that the guidelines were kind of best practice. Like, it's not rule, it's not statute, but it is a best practice to not go out there and do that. which is kind of a violation of their autonomy. I like that when you go back to the basic core principles, ethical principles. So we kind of decided in the end it was appropriate to include it because it's kind of an aspirational value or rule where we aspire to respect our client's autonomy. Whether there's a rule to back that up or not, it's still good practice not to go out there and do research on them.
Patrick?
Isn't it better to leave that up to the clinician to decide that rather than say you shouldn't do that as kind of the default advice? I mean, you guys are trained in this. Y'all ought to know when it's, kind of what's the best way to go.
Yeah, and I
Just-
wouldn't. Yeah, I wouldn't look at the policy as best practice. It's because it's definitely not a best, it shouldn't be a best practice. It's here's some recommendations. If you follow these, you can stay out of trouble. But again, it's a policy that we're never going to use as, hey, you violated this policy, now we're going to get you in trouble or discipline your license. It's when people ask questions, they want more information, they want to stay out of trouble, and we're just telling them, here are some guidelines you can do that if you do these bullet points, you're not going to run afoul of a rule. And that's why that particular bullet point, if you follow that, if you don't follow that, you're not going to violate a rule. If you follow it, you're not going to violate a rule. It doesn't follow this. The standard to me is you're giving them recommendations of what to do to stay out of trouble. And that one doesn't follow that standard, because if you don't follow it, you're still not going to be in trouble. That's not going to violate a rule. This agency can't discipline you for that.
I concur with the attorneys, Mr. Chair. And the other is, autonomy about the client, also the autonomy about the persons who are adults. And sometimes you can put in a name and search engines will, I could say SCOMA, and it could turn out to somebody else has a similar name to Chairman SCOMA this morning and has nothing to do with Chairman SCOMA. It's just a similarity. So also when and if some investigators come, not that you have to disclose it to a degree, did you not know this about your person? Or if this person is being counseled and you trying to get it the best ear and the best advice, then that's what may need to happen sometimes. And then somebody can say, well, the rule says you shouldn't be looking at social media, so I'm going to file a complaint. Now you have a complaint of a written process that's here. And now you've got to answer the questions, answer attorneys if they have one, and et cetera. So why would you set yourself up for those kinds of discussions when you have more things to do than answer these required documents, calls, et cetera? So I know it's maybe an extreme, but in this time of potentially litigious complaint situation, you might want to be aware of that, and then just say, hey, let them choose what they want to do in that, and that the not only should the client have autonomy, but so should the therapist. I'll yield there.
I want to jump in just for a moment and acknowledge that we've been joined by our most excellent colleague, Mr. George Francis IV, and welcome, Mr. Francis. We are on agenda item 10.E, which is your committee, and I want to invite you to join in on that discussion. We're currently discussing the proposed rules and guideline changes that you all discussed, and so just give you a chance to jump in on that. Sarah has given a brief summary of your reports.
Chair, and I do appreciate it, and I do apologize to everyone for the difficulties I'm having on my end. I'm very comfortable that Dr. Elder has been able to more than adequately represent the committee and the positions of the notes on it. So I will continue to join in. At this point, nothing more to add than what I've just basically have heard. And so know that I'm listening, and we'll join in just a second.
Thank you.
Do we need to take action on these dynamics or post it for later action, or
I have a couple.
Merchant, I'll throw it to you.
Okay. I guess comment number one is, would there be a way to exclude it from the bullet points, but still include it somewhere on the sheet? Maybe we could add another paragraph or line that just says, although this is not a rule violation, it still could be considered a violation of your client's privacy if you are seeking out information on social media about them. I don't know. Patrick?
Well, the one thing I will say, which I think Sarah did a great job at the very end of it, it talks about basically licensees are encouraged to review I think it's the AMFTRB guidelines, which is where I think this is coming from, which is a best practices standard. And it says, the board adopts them as they are, incorporates those best practices where congruent with state and federal law. Essentially what you're saying is you'd like for them to have some place that they could know this information. It's there, like so you have that link, you can go there, you can see the best practices. So if people want to look at, because I agree, I think this is what we're talking about as a best practice, which might be something that people want to look at and follow, but it's not something that we don't enforce best practices. So that's why I just didn't feel like it's a good thing to put on this particular sheet. So I don't know if it is any comfort, but the document's referenced, and then people can go there and they can see that, if that helps kind of include it in that way.
It doesn't really change anything to move it to its own paragraph. You're not changing the effect of that statement in the document. Take it out of that list of bullet points and give it its own paragraph.
Counselor Hyde, do you feel like this ties our hands in some ways by putting it in there that we wouldn't have to deal with in other ways?
I think Chaplain Soglin is correct in that people will look at this guideline and then they may start filing complaints based on a standard in this policy. And then we're going to say, well, that's not a standard we can enforce. So, to your question, does it tie our hands? I think it causes problems. Yeah, I think it can. Yeah.
I have another comment. Sarah, do you mind pulling that back up on the screen? The first time, I'll be honest, the first time I read the guidelines that were published by the psychology board, I found parts of them like, I don't know, almost kind of confusing. So as I read through it, and then I got to the first bullet point that says ensure that the proper informed consent is conducted prior to engaging in social media with clients. I was kind of thrown off by that sentence because to me it seemed like it is then like condoning that we can engage in social media with our clients. And when I think of social media with clients, like I'm thinking like my personal social media page, I'm not thinking professional because I don't have a professional one. So like, I think personal social media. And so there, if you scroll down to, I think it's like the 7th or 8th bullet point, where it says use separate professional and personal web pages and profiles. And then the one below it, politely turn down requests from clients. I think if those 2 bullet points were like the first on the list, as opposed to down in the bullets, it would kind of maybe help clarify that when we're talking about ensuring proper informed consent with, social media, that we're referring to professional pages, not personal pages. Because I just read these first few ones, I was kind of like, wait, you can't, I don't know. Like in my head, I was thinking, are they saying that it's okay for us to engage in personal social media? And so it wasn't until I got down here that I'm like, oh, okay, I guess it's not. I don't know. So in my opinion, I just feel like those 2 bullet points should come at the front end as opposed to in the middle. But maybe I'm the only one who reads it that way. I don't know.
No, Dr. Merchant, I actually agree with you. I think those 2 would dovetail really well together. And then if you're going to move bullet point 7 up as the second bullet point, I think it would also be wise to move bullet point 8, which is politely turn down requests from clients to connect on personal media sites. Since that's the same topic, move that to item 3, and then they're all kind of grouped together. And that makes complete sense to me.
Yeah, well, I was thinking about doing use separate professional and personal as 1, and then politely turn down as 2.
Mm-hmm.
Okay.
Sure. And where does then the first bullet point, where would you want that? Ensure the proper informed consent is conducted. Where would you want that to be?
Let's make that number 3.
So the first would be maintain appropriate professional boundaries.
No, number 1 would be
No.
use separate personal or use separate professional and personal web pages. And then 2 would be politely turn down requests from clients. And then number 3 would be ensure the proper informed consent. And then the rest would just follow.
It seems to me that the two that we're discussing really fall under the umbrella of maintaining professional boundaries, whether online or in person. So maybe that should be first to set up the dynamic of professional boundaries, and then say specifically when it comes to social media, here are the guidelines. It seems to me that would be reversed if we give the specifics first and then the broad.
Okay, so which one would you say to put first?
I would say maintain appropriate professional boundaries first, because that's the big dog. And then whether online or in person, and then go to use separate, could we go to then the online specifics, use separate professional personal websites,
Yes,
and
that
then
makes
politely
sense.
turn down, and then ensure proper informed consent. Because
Yep.
consent and boundaries are two different issues. Really.
Yeah, that makes sense.
Are we doing, is this an official suggestion that we're making now? Do we need to make some kind of? Okay.
A motion could
Motion.
be made to adopt this guideline as with changes as discussed, or the motion could be to table it, or whatever the board determines. But I believe that Attorney Patrick ruled that proper notice was given, so a motion could be made on this particular document.
Well, let's make sure we've got it all the way we want it before we do that. So is there any more discussion? Other changes in these? Is everybody okay with those changes?
I like that because it goes from the macro and then it starts to give some illustrations.
And I'm going to make a motion that we maintain appropriate professional boundaries with clients. The first bullet point, the second bullet point becomes use separate professional and personal web pages. The third bullet point become politely turn down requests from clients to connect. And then the fourth bullet point, ensure that the professional consent is conducted.
Right. And I like that because that flows better because you've got that topical theme and now you're kind of specifying and illustrating each of those points.
Dr. Barty, can we take that as a second?
I will give it as a second.
Okay.
Discussion, Mr. Chair.
Discussion, questions.
Yes, thank you, Mr. Chair. I just want to make certain that when we talked about the social media piece, the last one, the board viewing your clients, is that part of this or is that a separate motion? Just to be clear.
It would be a separate motion. I did not include it.
Okay, good to go.
So this is the language that's already in place, correct? We're just making shifts to what language is already there. We're not adding language. That's another issue that the Rules Committee has proposed we can deal with. Okay. Any further discussion, questions? Is everyone clear on what we're voting on here? See, okay. Those in favor of accepting these changes as proposed by Dr. Merchant, please signify with a raised hand. I count 6, so I believe that's unanimous. What else under Rules Committee do we need to?
Are we going, what do y'all want to do about the avoiding social, that piece of it? I mean, I teach my students, I teach our ethics class and I teach our students to not go hunting down information about their clients. So I don't know. Again, it feels like an invasion of privacy for me, which is why I like the idea of having it on there. But I also do see the point that all these other things are things that you can actually get in trouble for. I don't know. I can see both sides of it. So do we want to have further conversation until we can reach a resolution? Or do we want to table the issue, or do we want to send it back to Rules Committee, or what do y'all want to do about this?
This is Jody. So I would add something that Mr. Francis shared in the Rules Committee meeting that I thought, wow, well, that's a good point. And he said, is this like common knowledge that everybody kind of knows, where you could find it in a book somewhere, you could find it in an ethics code somewhere, or is it just kind of an unspoken thing? And I know that it's just kind of like counselor wisdom that's passed down from, people like Dr. Merchant and myself when working with supervisees, but I don't know that I would find it written anywhere. And I think it would behoove us as a board to say, we kind of expect you to do this. Now it's in writing. And I also understand the perspective of we're putting it out there, but it's not enforceable under a rule. But I think I don't know, I wonder if we had time to kind of look and find a rule that we could make that stand if a client did actually make a complaint against it. But my suggestion would be that we move forward with an up-down vote on that particular bullet point and get these published one way or the other.
For the board's consideration, I seem to recall there was a point made. Am I muted or anything?
We can hear you.
Okay. There was a point made that under certain services, such as forensic services, that indeed the counselor sort of investigates and maybe doesn't take everything at face value. So should this language, or could this language be included, but teasing out that application of that, rather than avoid, maybe be careful of viewing your client's presence? Does that make a difference to our attorneys or to those that might be practicing in a forensic sense?
Or I like what Ms. Basselt just suggested, avoid viewing your client's presence on social media unless it's part of a forensic custody evaluation, right? That carve out, I think, would be helpful.
I think I hear that we can even table this, but I think you're going to potentially have someone who is upset about the counseling, and the therapist could be spot on, but then they're going to use something. I think we're opening the potential of Pandora's box by saying avoid social media. You have a computer that sometimes, because of information that overlaps that you have no intentions of doing. And I'm not talking about pornography, that's a whole different story. But I'm talking about just in general on the computer. Now you're saying, well, gosh, I'm gonna get in trouble potentially if I just say John Smith, whoever John Smith is. Now, well, they're gonna complain. So I think we may be over invading somebody's doing that. So I just think we might want to avoid that. I would vote at this point to just strike it out in its entirety. And then if you want to come back and look at it or have some other statement, but to avoid viewing clients, you're not spying. You're just trying to figure out how to help these people in their situations.
Well, I think when my students do it, it's their spying, to be honest. I think it's just out of morbid curiosity about our clients and our lives, which is why I discourage students from doing it.
Right.
So I wonder if a way maybe to do it, what about this? Maybe this would be a compromise. Avoid viewing your client's presence on social media without consent or clinical reasoning or something, or without clinical, I don't know.
So you're giving an out so that the clinician could say, I had valid professional reason to look at this.
Yeah.
So if there were a complaint made, they could have the out to say it wasn't just consent. I didn't have consent, I grant that, but I had valid professional reason.
I had concern for some reason to seek this information out. I don't know.
Yeah, the only time that there would be is if the client is going to say, hey, look at this picture, or look at what I posted. That's client initiated or it's court directed. So I think at some point in the training, even the word avoid, to me, when I'm instructing, I tell them, do not view your client's presence on social media. You don't do that. Now, if they say, I want you to look at this post, you have client permission. Or if you're directed by the court for forensic purposes or whatever it may be, then you have permissions. But other than that, don't research, don't be a voyeur, don't, just be curious and just be bored and start looking up things. And don't actively do that. Now that doesn't take away the anecdotal, like if this is something that's in the media, if this is something that's in the newspaper and you have a client that is in the newspaper, that doesn't address this, because that's anecdotal. That's going to happen anyway because you're a citizen. But the researching and the seeking, I really come down pretty clear and pretty hard fast. You just don't do that. As a clinician, you stay with what the client presents in the session, and that's it.
Dr. Barti,
Go ahead,
Sorry.
Dr. Elder.
I really appreciate the wording that you just provided. You said avoid viewing your client's presence on social media unless client initiated or court directed. That's it. That's beautiful. I love that. And I think that gives us the loophole that we need legally and preserves what Chaplain Stoglin said is the clinician autonomy, but also really encourages clinicians to preserve client autonomy. And I think that's a beautiful middle ground.
I think, excuse me, both of you, Dr. Barti, you framed it in my mind very succinctly. Thank you. But I'm going to stop and ask Attorney Patrick, okay, you now have a complaint, hypothetically, of Jane Doe saying that they looked at my social media. Now, that's it. I don't like them doing that. That's the complaint. I don't like them doing that. I don't like my therapist doing that. Now the complaint is to your office. What do you do, Attorney Patrick?
Yeah, while I appreciate the clarifying language, and I think it's, potentially better, it doesn't fix the ultimate problem, which is that, that's not a rule. There's no actual rule being violated when they do that. So if somebody has a public account of Facebook or whatever, and anybody can go view it, and they happen to click and see it, while it might violate a best practice, there's not a specific LMFT rule that they violated. So it doesn't change that. So whereas all these other bullet points, I can point to, they violated confidentiality, or they violated informed consent, or, there's some specific rule. That one in particular, there's not a rule.
Well, how would the practitioners view it if someone presents as suicidal or homicidal in a session, and you're like, oh, man, I don't know. Isn't that a legitimate reason to go look at some publicly available facing information so that you can make a better decision about whether to inform law enforcement or medical personnel under 611 of the Health and Safety Code? To me, we're kind of tying your hands as practitioners here by putting it out there about, well, you shouldn't do that. You can't do that unless you consent to it.
I mean, the only reason that I would send a student or anybody to go look at a social media page for, to see if somebody was suicidal would be if we had direct, if a parent contacted us and said, my kid just posted something on Facebook and I think you need to see it, Otherwise, I don't think I would be like, hey, students, y'all go monitor their Facebook page to see if they're posting anything that makes you think they're suicidal. You know what I mean?
See, I'm not talking about blanket monitoring. I'm talking about in those situations where you have, so you may not have enough evidence that you're just confirmed that, okay, there's a threat to either their own safety or someone else's here. But if you've got some credible indicia that there's a problem here, we've now tied we've tied. Part of the problem is we're all already falling into the mindset of we're viewing this as something that is a mandate or a rule, and it's not. But even listening to y'all talk, I can tell your mindset is already changing and falling into that trap of, well, we're viewing this as having the force and effect of law. And that's the problem that Patrick and I are talking about, is you throw this out there, I promise you, people are going to view it as, well, I don't know if my guy's going to beat his wife or not.
Yes, a potential Pandora box. Absolutely.
Can I, as a public member, be direct with you? I feel caught in between two groups this morning. I've got the professional members of the board that feel strongly this is a best practice. And then I'm hearing from the legal and professional staff that while this may be a good practice, this may not be the best place to codify this. And so me is caught in the middle. While I agree professionally, I can see you teaching that and that's good. I would be tempted to vote against this adoption because I do think maybe good idea, wrong place. And it sounds like maybe you feel passionately enough about this that maybe you want to propose later that it become a rule with some teeth to it. But I think if we were to take a vote right now, I'm going to side with staff that this could be more problematic in the way we're doing it than the basic idea of what we're trying to do.
I think Dr. Elder, what really kind of sold me in the rules meeting was when she explained that the assessment of an individual comes from what you discover and what you find out in that meeting, in that room with that person. And based upon that is where you make those decisions. It's not going out on outside media or materials to discover more things. And because of that, I'm kind of leaning on the professional side of this, where we need to have more of this than less of it. And so I understand your position, Chair Skoma, today, but the way that it was articulated in the rules meeting by Dr. Elder, I too saw it just like you did. And she really kind of swayed me the other way of understanding those things need to be discovered in the room and not outside the room. And that's what I would leave it at.
And again, as a legislative body, as a regulatory body, we have to determine, yes, what the right thing is, but then also the right way. And I think what I'm hearing is the professional side saying this is the right thing, and the legal side is saying, but this isn't the right way, is my view on it. And so maybe we need to find another way to do that.
And one of my concerns, I mean, again, I can see both sides of this. So I don't honestly know if we voted this moment, I don't know which way I would vote. But I think one of my concerns about having it on there is I don't want to also make the public think that they have some protection that they don't. You know, I don't want the public to see this and think my therapist can't do this. And then they file a complaint and realize that that protection really truly doesn't exist, you know? So I also worry about that just from, I don't want them to think that there's a protection that isn't really there.
And as a professional, thank you, Dr. Merchant, but I'm with Chairman Skoma in this. You've heard that, and I understand the validity of your concern. And Dr. Bartia again framed it in a great way. But you potentially tie people's hands. You're going to potentially tie up staff because somebody's going to complain, and then you got to answer those complaints. And it's like there's nothing we can do. This is not the law. You didn't act unethically. You just wanted to see if you can help this person, and just by looking up something, and that's it. You're not being Dr. Bartia. I agree. You're not being a voyeur. You don't go and say, well, go look up Dr. Bartia, or go look up John Smuckatelli, whoever that is, or Mary Wallflower, just to see. No, you're looking for something to help the client. But the client finds out, they file a complaint, and you could be, again, the therapist could be spot on about what's happening, what the recommendations are, et cetera, but they just angry. And so now you've got a complaint. Now Attorney Patrick and others have to look at that. Now you've got staff, now you've got process, now you got to answer. And so while they are already busy, and that's their job, but at the same time, why would you potentially open up Pandora's box? Because you feel better but by having that. And that's basically what it is. You feel better. Well, the citizens of the great state of Texas want you to feel better, but they give us the latitude of saying, let's make it better for everybody as best we can, for the client and for the therapist and the academicians who are teaching our potential practitioners. And I'll yield at that.
Yeah. Kind of address this to Mr. Hyde. These are guidelines, right? And guidelines really don't have teeth, right? The second section are penalty. I mean, those are the ones below that. Those are penalties. I mean, those have teeth. Is that right?
Well, look, to back up, so we don't want this to ever be interpreted as what's called ad hoc rulemaking, because that would be basically an illegal rule, basically a rule that didn't follow the formal process of notice, opportunity to comment, publication, those sorts of things. And so the policy, you're right, the policy is not a rule where we will never say you violated this policy. And so the second set of bullet points are examples of things that the agency can take action against someone for online sexual misconduct, inappropriate communications, misrepresentations, etc. So it's examples of those, and it's not meant to be an exhaustive list. That I think the issue is all of the other bullet points above that dovetail to those other ones where you can say you can get in trouble for those particular things. Whereas that last one that we had talked about, avoiding the social media, viewing social media, there isn't anything that the public can look at this and say, oh, they're not following that bullet point, but not following that bullet point doesn't dovetail to any particular rule violation, and so we couldn't do anything for it. I think it might be misconstrued or it might misinform the public reading it, and they may not understand it. So does that, I don't know if I'm answering your question, but I hope so.
No, it does, because that second set of bullet points, it says online violations of client confidentiality. And I don't know if that would be like that unprofessional behavior that might require or might prompt disciplinary actions. If that's the one that has more teeth than the guidelines above, because the guidelines above are going to be, this is what we really would like for you to adhere to.
Yeah, I mean, what the guidelines above are essentially meant to do is, so we get emails or questions and calls from people all the time about big issues like, let's say, like social media, and they're wanting to stay out of trouble. And so the guidelines are basically to try to help people, steer them towards a path of, I want to navigate the world today, have my practice, have a social media presence, but also not get in trouble with board rules. And so these are, if you follow these steps, you're not likely to run afoul of any of our particular rules. And so they're typically sort of things that create make sure you're maintaining your own personal and your professional lives, and you're not violating confidentiality by sending a tweet saying, met with my client, Mr. Smith, and he told me and I want to share some new, clearly not stuff you should be doing. So this is just sort of, when people have those questions, you can direct them to this and say, here's some guidelines you can go to get more information about how to avoid getting in trouble.
Good. Dr. Marchant, and then I'd like to make a suggestion.
This is a little bit off, so I don't want to derail the conversation, but I noticed that last bullet point is making online, what does it say, derogatory? I gotta go back to it.
Online derogatory remark regarding a client.
But does that just mean, is that just about any, like if or it says discriminatory, online discriminatory language or practices. So does that mean that like if a therapist were like to say, use like a racial slur or something online, that they could get in trouble with the licensing board?
Well, I think the potential violation there, right, is you're making remarks online and you're bashing a client. How is that therapeutic in nature? How is that not a violation of confidentiality? I guess.
But I mean, is it only then for clients, or would it be any discriminatory language or practices? Well,
if you were making derogatory comments about your next door neighbor online, that would not be a violation of any particular board rules, because you're not operating within the scope of your license, within the scope of your practice. We don't regulate your personal life. You can be a jerk in your personal life, but that we don't have you got to be a nice guy, both professionally and personally. So.
Well, then I'm wondering if that statement should be amended or something. I don't know. I would just read it as like if somebody were to. Well, I don't know.
Let me. One thing I want to make clear is we're never going to cite to these guidelines as a basis for a violation. So I know, Dr. Marti, that was one thing I want to respond to you on is you're drawing a distinction between the first list of bullet points and the second. They're all guidelines. You're never going to see a notice of violation that cites to this as, hey, you violated this provision here, because it's totally unenforceable, everything in this document. If there's any violation, we'll have to cite to an actual rule or statute in law somewhere. So just want to make that distinction.
I feel like we've had a healthy discussion on this draft proposal for guidelines for using social media. I'd like to invite perhaps Mr. Francis, as the leader of the Rules Committee, to tell us what you want to do. Seems to me we could offer to amend, to table, or to vote on what we have before us, but I'll leave that in your courts. But I think we're ready for action on it.
Chair Scoma, I actually don't know. I would go with whatever the decision of the board is of what they would like to do. And so I'm open to hear a motion of how the board would like to proceed with this, please.
Mr. Chair, for today, I would move that we table this item for later discussion.
Okay.
So that we can get clarification.
Have a second for Chaplain Scoggins' motion for tabling. Okay, Dr. Barty, we have a second. You'd like to discuss that before we take it to a vote?
Mr. Chair, excuse me, Mr. Chair, I'm just saying in the discussion portion, and I'll yield after this, is that we need to have clarification and input from our professional staff and our attorneys so that if we come back with this for action, then we have clarity on what expectations are and how to properly word it so that the client will feel safe and the therapist will feel safe as well, and have options to help potential clients when they come for assistance. I'll yield at that, sir.
I wasn't aware. Someone else spoke up and I couldn't tell who it was.
Yeah, I was just going to say, if it goes back to the Rules Committee, just to fine tune and tweak and just kind of solidify based on this discussion as to either just affirm it as is or maybe modify it based on some of the comments and then present it back to us so that we don't kind of micro hash out too much during this particular meeting.
So we've got a motion, we have a second. Could we get a vote on those in favor? Here's again, we're voting on those in favor of tabling
Sure.
draft of guidelines.
Chairman,
Yes, sir.
Chairman Scoma, I thought that Dr. Elder had a comment that she wanted to make before we go to the vote,
Apologize.
please.
It's hard to see sometimes on this, so if I'm speaking over you, you just speak up.
Thank you, Mr. Francis and Mr. Scoma and Dr. Scoma. No worries. My question was, if we table it, what happens? Like, what is the other information we need to have in order to move forward with this? And it seems that has been answered, which is just boot it back to the Rules Committee for more discussion. And yeah, there you go.
In my experience in the legislative process, tabling is a polite way of, if you vote something down, it doesn't get brought back for a while. If you table it, you can bring it back. And so it's a polite way of saying we need to work out the.
And I'm just suggesting wordsmithing.
Okay. Would it be possible for Dr. Barty to email the Rules Committee with suggestions for wordsmithing so that we could take that into consideration during the meeting?
I can invite all board members to provide me their comments on this piece, on this document. And I can provide that to the Rules Committee before it convenes.
That'd be great. Thank you.
Providing an opinion or providing a wordsmithing?
Any comment the board member wants to make?
An opinion on wordsmithing.
Yeah.
Has everyone had a chance to speak? Any other questions or comments? Okay. Then again, we're voting on the motion we have before us to table, to send back to committee, the draft on the guidelines for using social media. So by a show of raising hands, those in favor? Those opposed? And none abstaining. So it looks like on a 4-2 vote, was that your?
That's what I
saw as well. On a 4-2 vote, the motion carries. And thank you, committee, for your hard work on this. This is a great deal of work, and it really is taking us in the direction we need to go, and we'll get there. So thank you. Is there anything else we need to discuss from the Rules Committee, either of these other two documents at this time? the guidelines for technologically assisted services. Anything we need to do with that?
I think we decided to wait on that until the actual rule was adopted.
Okay. All right, well, that concludes then our reports from the committee chairs. Thank you very much for your hard work and your reports today. Moving on to agenda item number 11, discussion and possible action regarding the jurisprudence exam, which we've just heard about earlier. In lieu of the absence of Chairwoman Husband Thompson, who would like to lead us through the discussion of these points under agenda item number 11?
I can do that.
Chairman Marchant, look like you were going to say something.
I was, but if Sarah wants to continue, then I was just going to make a motion that we accept it. But if there's further discussion.
So I think agenda item 11A is actually the vendor's report.
Okay.
And it was included in your meeting materials. If you have any questions about the vendor's report, I'll try to answer those.
That is.
Then hearing none, 11B is the discussion and possible action related to changes in the board's jurisprudence exam. As part of the Professional Development Committee's report, you have in your board materials a more detailed description of what the Professional Development Committee reviewed and their comments. So
That's 10D, is that correct?
it was correct.
Yes.
So if you have any questions about that, or if Chair Scoma would like to entertain a motion on whether the board would like to proceed with the changes suggested by the Professional Development Committee or some other action.
Ready to entertain a motion?
I will make a motion that we proceed based on the recommendations of the Professional Development Committee and all the hard work of Drs. Barti and Elder. So.
Can I get a second? Okay, thank you, Chairman Scogin. So that being said, discussions, questions, comments? Seeing none, let's take a vote on accepting as proposed this actions related to change in the board's jurisprudence exam. Those in favor of receiving these changes, show of hands. Those opposed, I'm sorry, saw your hand, Dr. Francis. It looks like that was unanimous. So that will be accepted. Thank you. Great job, committee. All right, that moves us then to agenda item number 12, discussion and possible action to re-elect or replace the vice chair of the Texas State Board of Examiners. I'm going to ask Dr. Marchant to take over this portion as it involves mine.
Reverend Dr. Scoma is willing to serve as vice chair again. Do we have any other nominations or recommendations for vice chair? Okay, I'm hearing none. Can I get a motion to approve Reverend Dr. Scoma? Okay, that's Dr. Barti. Do I get a second? Chaplain Stoglin. All those in favor? Okay, that is unanimous. So congratulations, Reverend Dr. Scoma. You are again our vice chair.
Thank you. For the record, that's an abstention. Thank you. Moving on to agenda item 13, the discussion and possible action to re-elect or replace professional member delegate to the Texas Behavioral Health Executive Council, whose term as delegate expires February 1st. This is currently Dr. Smith, and we'll open up motion to appoint a candidate for this. Dr. Barti?
I'll make the motion to accept Ms. Smith in this capacity, to continue in this capacity.
I'll second.
With extreme positive prejudice.
Extreme
If I can do that.
Yeah.
Positive prejudice.
Absolutely.
Echo that.
Yeah.
Thank you. I think we can take a vote on, I guess we should open that up for discussion. Seeing none, those in favor, show of hands, and that is unanimous. So congratulations to Ms. Smith and commendations on her excellent work. We are in great hands with her there, and I feel that today in her absence. It shows us how much she carries there. So it's congratulations to her and thank her for her service. All right, agenda item number 14, discussion and possible action concerning public comment on proposed rules published in the October 1st, 2021 Texas Register regarding Title 22 of the Texas Administrative Code. You could read those there below. It's my understanding that we did not receive any public comment. Would that be correct?
Sorry, I can't find that.
It's okay.
Say that again, Sarah.
She is looking.
Looking. No, I have no public comment.
Okay. That being the case, we have the option of amending or adopting as written the changes proposed under A and B of item 14. So can I get a motion? Dr. Elder?
Make a motion that we adopt the rules.
Thank you. Dr. Partee?
Second.
Second that, okay. Questions, comments, discussion?
Real quick. Under B, the application to take licensure exam, in our last meeting, there was some discussion about adding an FAQ to our section about, yes, you can take it in your last semester, and that has already been added. So thank you, staff, for your diligent effort.
Thank you.
Thank you. Any others? Okay, we have before us a motion to adopt as written these two changes. Could I get a vote on that by show of hands? Those in favor? Looks like that passes unanimously. Thank you very much. All right, agenda item number 15, discussion and possible action regarding potential changes recommended by the MFT Board's Rules Committee to Title 22 of the Texas Administrative Code, Section 801.44, Relationships with Clients, which clarifies that the same competency standard applies to emerging areas of practice for which generally recognized standards of preparatory training do not yet exist. I asked Mr. Francis if he would want to explain this to us, and then we can move on to official action.
And I apologize, Chair Scoma. I don't have a computer. My computer system is down, which is some of the difficulties that you're seeing. So I don't have any of my notes in front of me, so please forgive me.
No worries. When you left Dell, was that part of the agreement? You couldn't use computers anymore?
No, when I joined Amazon, it was, you don't get the quality of Dell computers anymore. That's the.
Very good. Would anyone else on the committee like to address those dynamics?
This is Dr. Elder. So the reasoning for, excuse me, this new rule proposal is in the Psychology Board's guidelines for the practice of telepsychology. They included, which we were asked to review as kind of a draft or foundation for creating hours. There was a section where they talked about with emerging areas that, such as telehealth and telesupervision, that you would just be diligent basically in the way that you apply that and make sure you have competence training, you know, you're working with somebody who knows what they're doing, et cetera. And when we looked further, we realized they actually have that rule, and they cited that rule in their telehealth guidelines. And so we thought, well, it'd be great for us to have that rule so we can also cite that, because it's not only applicable in the area of telehealth and telesupervision. There's lots of things going on in the counseling world where psychedelics are being used with clients, and that is definitely an emerging area. So it's basically just a rule saying whatever the new area is, make sure you're diligent and doing no harm.
I like this rule. It also, WMFT has a similar rule in their ethics. I like this, and I'm happy to see it here.
For the board's consideration, it looks like a word was omitted in the, it originally states as presented to the board, licensees take reasonable steps to ensure. So I propose to the board, you might add the word must, licensees must take. And I'll rely on the attorneys to correct me if that's a mistake.
For those following along, this is item 15 point P, 801.44 sub letter P. Council, is that agreeable to you? Would the committee be agreeable to add must?
I think in the wording that we adopted directly from the psychology board, the word must is not there. I think it's implied, but I'm not opposed to adding it if Attorney Hyde says there's really no negative legal implications to doing so.
Yeah, when I looked at the rule from psychology, the only word that was taken out was it had the word patient, and so I struck that and put it in, but I didn't put a must or shall. I guess, yeah, I think you're correct. It's a sort of an implied, but I think putting a must or shall maybe makes it potentially clearer. I'm trying to think if it should be a must or a shall.
It doesn't make any
Doesn't matter.
difference.
No.
No, it's
I think
both rules are mandatory.
It doesn't make any difference must or shall, or doesn't make any difference putting it in there at all?
It doesn't make any difference putting it in there or leaving it out. You can do either way you want.
it does with O and Q, it's nestled in there. Those are must, those are must, those are must. And so I'm leaning toward inserting must, just to maintain the
Order.
the
Even the
magic of that.
P, it does say must.
Yeah.
Then can I make a motion that we accept this rule change with the addition of the word must?
I get a second?
Second.
George.
Thank you. Discussion? I do have one point of clarity because this has come up before. Is it my understanding, this is the first time I've heard this. So in the psychology board, they use the word patient, but in our field, we use the word client. Is that correct? Okay, thank you. Helps me.
Well, psychology uses both.
Okay. But they're doctors.
Dr. Merchant mentioned earlier about she was confused about something the psychology board wrote. I was muttering under my breath. I was muted. I was like, I'm shocked that anybody's confused about what the psychology board promulgated. Don't anybody in the audience go tattle to me now and get me in trouble over there. But yeah, they use both and they mean different things in certain.
My understanding is they're much closer. They operate much closer to the medical model. And we have kind of moved away from that, and we are focused on what's called a wellness model, which doesn't pathologize using the word patient. We see them more as clients, where we're kind of walking on the path with them rather than being the expert that's over them.
Okay, let me.
Well said.
Well said. Any further discussion? Allow me to just read the language for those following along at home, just so we're all proper. But the motion is to add to Rule 801.44 subsection P to add the following: in emerging areas in which generally recognized standards for preparatory training do not exist, licensees must take responsible steps to ensure the competence of their work and to protect clients, research participants, and other affected individuals from the potential for harm. I'll entertain a vote now. Those in favor of adopting this language, please signify with the raising of a hand. 1, 2, 3, 4, 5. It appears to be unanimous. 6. So thank you. We will adopt that. And again, Rules Committee, thank you for your work. Moving on to agenda item number 16, discussion and possible action concerning potential changes in Title 22 of the Texas Administrative Code put forth by the Council Standardization Work Group. Normally I would throw this to Mrs. Smith. Who would like to address these items? Who's the knowledgeable person here?
I could speak a little bit since I work with that standardization committee.
Sir.
The first issue is what we're trying to do is we're trying to standardize the language across all the boards about how continuing education is handled. That will help the agency staff on the back end. That way we're not having to fumble around with, different hours or just different language. All the boards handle continuing education in a different way, and it makes it a little more difficult to administer. The big changes that I want to point out here is that I think y'all already require the 6 hours of ethics, so I don't think there's any change there. There is the committee is recommending 3 hours of cultural diversity or competency. I can tell you where that came from. It came from Psych Board. Psych Board actually uses 6 hours of those, but the committee is just recommending 3. That recommendation for cultural competency and diversity continuing education is actually in the state health plan. So I don't know who promulgates that. Somebody over at HHSC, one of those divisions over there. We tried to have some discussions about the standardization of the overall number of hours, like y'all require 30, Psych Board 40, LPC Board 24. Those discussions fell apart real quick. There was no way we were ever going to achieve consensus because everybody's special and unique, apparently. So that didn't go anywhere, but we did get consensus on the rest of them. So that was a big win in the committee. One thing I don't think y'all currently have it in your rule, the carry forward provision that you see there on in number A3. I think that'll be new for y'all. Folks can carry forward up to 10 hours that they don't need for the current renewal cycle. And it's only from the previous renewal cycle. So I don't want you thinking people can bank from 2 renewal cycles back. It's just if you got 10 extra hours, you can carry that forward. That will become particularly useful if I can convince the council to move to something like CE Broker, where it's an online system that tracks accumulated hours, tells you, okay, you got enough or you got more than what you need. And then that system will carry it forward for you. Subsection B for y'all is, I think y'all already require the 3 hours of continuing education for supervisors, board supervisors. That they're increasing that up to 6 is the recommendation. And then of course we've got y'all's telehealth, your 2 hours of telehealth. That was something Janine insisted on being in there. So that's still in the rule. No other board has that. I will say that y'all are unique and that you're the only ones that requires that additional continuing education. The rule in C, we've defined what is acceptable as far as ethics hours go. I think that'll be beneficial because that stops us from the staff level having to try to figure out, tell people, hey, what is ethics and what is not. Sarah, can you scroll down a little bit more for me? And I apologize. I'm already losing my voice. I don't know if my wife's prayers have been answered or what the case is, but I tend to lose my voice rather quickly. Cultural diversity and competency, we've defined what that is there in D. And then what we're trying to do in E is we're trying to, the boards have handled what is acceptable in different ways. We want to make sure that any continuing education you do is directly related to the practice of fill in the blank, marriage and family therapy for you guys. And we're trying to, we're also trying to say, I think it's in E, maybe it's a little bit later on. Anyway, F is something that's going to be new to y'all. This is something that Psych Board had done. What we said at Psych Board was, look, we know there's this full range of continuing education programs out there, the quality of which varies greatly. So we want at least half the hours that licensees get coming from this list of approved providers. We're not in the business of approving providers anymore. We can't be in that business anymore. We're just not equipped to do it. But we can set up a list of approved providers, and you have to get at least half your hours from somebody off that list or somebody that they have approved. So F is that list. Now, the other half of your hours you can get from somebody not on the list, but I'll tell you from practical experience, you're going to find that almost everybody gets their hours from approved providers because it's just easy to do. I don't really see anybody that gets hours. I'm sure there are some, but the vast majority of people are going to get their hours from approved providers. At G, scroll it down a little bit more. Boards were all over the place on how they awarded the number of credit hours. Some people would say, well, for 3 hours of writing a book, you get 1.5 hours of continuing education. And I'm like, I don't want to be doing math 4 different ways for 4 different boards. So you get 1 hour of credit for 1 hour of work. And then the committee said, we'll just cap the number of hours you can claim in these particular categories, whether it be for presentations, book writing, teaching, or attending a grad class. We don't want to be in the business of having to use different formulas for different boards. We just want to say it's a 1-for-1 and you get a maximum of. And so that's how we came up with what you see there in G and later on in H and so on. The couple of things in H I want to point out, and I've got them over here in the comments, is your passage of the juris is, I think, required for a supervisor now. It would become optional under this rule. And then the self-study component. Now, I'll tell you, Janine doesn't like the self-study component. But I want to encourage y'all just take a look at it. We've capped it at an hour. And what I'm kind of envisioning with self-study is like, I know all you guys read all the time. You're reading journal articles, you're reading all kinds of stuff that's related to the profession. We're just trying to give you credit for that hour. I mean, come on, guys, it's an hour we're talking about here. I'm not making or breaking your continuing education there, but just to be fair, Janine, she wasn't a big fan of that. And neither was the professional association representative from Psych on that. They had some pretty colorful comments about why that was a cruddy idea. But
can you provide some commentary on why they did not support that piece, please?
Because they said, well, you could read the example they gave is, well, what if they read Chaucer's House of Bath as an example on, male-female relations or husband-wife relations? You could be reading some questionable content and then claim it as continuing education. And I'm like, that's true, but you can also go watch or pay money to attend some questionable content and still claim it for continuing education. So, I don't know. I don't buy that argument, so to speak, but it's ultimately it's y'all's call. But
Mr. Spink, did this language come from another board or another group that does this already?
The state bar, that's where I got the idea is I can claim, I think, up to 2 hours per year for self-study. And it's pretty loosey-goosey. It's just the bar says, self-study, and they don't ever
reading comic books. We know that for the
exactly. So that's where it came from. And I know there's a lot of, you have to do a lot of homework to stay up on top of things in the profession. And it's a little bit of an extension, an olive branch, if you will. So we'll give you credit for some of it.
When you report it to the state bar, do you have to report what you read? Or do you just say 1 hour self-study?
We just say 1 hour self-study. Now, somebody would have to maintain what for y'all. I don't know if the state bar does audits. I don't think they do. I mean, maybe they do. I've never been audited, but for y'all, if you get audited and you're claiming that, we're going to say, well, what did you read? You're going to have to maintain some proof of what you did. So, and that goes down a little bit later on under J there, you got to maintain proof of your continuing education compliance. So it may just be a note, I read this in the New England Journal of Medicine, or you may keep a copy of the cover sheet, just something that you can justify that 1 hour.
So I'm wondering if maybe the best way to approach this would be to kind of go back to the top and just kind of discuss these changes kind of one at a time. Does that work?
Sure. And Dr. Marchant, when it comes to administrative code, that's just, we have to vote this up or down like anything else. Is that correct?
I think that we could vote to adopt the whole thing, or I would imagine that we could adopt it with these amendments or these changes.
I'm just clarifying that this works the same way as any of the committee that we're dealing with.
For clarification for the attendees, at this stage of the rulemaking, the board would recommend to the council proposed rules be published. So it's not yet to the adoption
That's
stage.
right. That's what I'm trying to clarify with the new BHEC process for my own stuff. So we're making a suggestion with this to the higher ups. That be fair?
It would go to BHEC next, and they would have to vote. And if they could kick it back to us, or if they approved it, then it would go to the registrar for public comment.
So we're saying this is what we recommend to the BHEC. That's great. Thank you.
But just
So do we have a motion to do something and then discuss? Would that be
I think
appropriate?
we should discuss first.
Okay, great.
So I don't know about you guys, but I'm pretty comfortable with these first changes, the 6 hours of ethics and the 3 hours of cultural diversity or competency. Any opposed?
Sounds good to me.
Okay. Hold on, I gotta move my screen. I am comfortable with kicking this up to 6 hours of continuing education for supervision. We all good?
Can you tell me what item you're on? Because I have some comments, but I don't want to.
Sure.
You're talking about B1? Yeah, okay.
Yes, B1.
Then I'd like to go back up to A3.
Okay.
I'm
Oh, yeah.
absolutely, I'm absolutely like, yes, let's be able to move some things forward because some years you get more than others, yada, yada. My question is just procedurally, A3 seems to directly conflict with E1. And I would suggest that E1 have some wording added to it that said, unless it's allowable under A1 or A3, so that people could understand that allowance.
Yeah, I noticed that contradiction too. And I
Well,
like that. Go ahead,
It's
Daryl.
the more specific is going to control over the general, and you've got A3 is a specific provision that allows for carry forward. So you really don't need that unless language down there in E.
Could it be confusing for clients though, if they read that without having read the other?
It would be confusing for me as a clinician. Which one do I follow? I mean, staff would clearly understand which one, but for me as a clinician, I'm reading it going, they say different things and I need to know what to do.
So it looks like staff is making a suggestion that would clarify that unless allowed under A3. That language sounds good to me.
I like it.
Bam.
Okay. Thank you, Dr. L. That's a good point.
Okay. Sarah, can you scroll back up?
I tell you what, rather than saying unless allowed under A3, why don't we say under A3, we say notwithstanding E1. That's the typical.
I know, but I don't understand that. I would not know what that meant. Sorry.
That is lawyer speak, which is okay. I do think the others, it's more clear. Mr. Spinks, would it be wrong to do it the other way? It might be.
No,
right.
no, it's not wrong. Part of my hesitation is we're trying to standardize all of this, and I don't want to. Ultimately, it's y'all's call, but I'm like, we need to stay away from tinkering with this stuff and making it too, getting too far afield, because part of the whole point behind this was I want all y'all's, the operative language, the procedural mechanisms to look alike so that we don't have any kind of, deviation or variation there. But
I think we've expressed our reasoning.
I think you're
that.
okay.
We'll let Mr. Francis and Ms. Smith argue on our behalf at the next meeting. You guys can do whatever you want with it. All right. So we're going to leave that in, Sarah, what you typed?
I kept it.
Yeah.
Under E1.
Yeah, I think we leave it there.
No motion's been made, so it's. I'm
Right.
just
We're
making
still walking
notes.
through, but yeah, for the motion, I leave that in.
Any other comments about B?
Specialty
Let's move on to C. I like C. Any questions, comments, thoughts under C?
I remember making this suggestion like 2 or 3 years ago and it getting voted down. So I'm excited to see it in there. This is exactly, I know we can't regulate, but to have, hey, at least have them have to come from these sources. I like this a lot.
Can you scroll down to D, Sarah? Any questions, comments about D? I don't see any areas that I would add. I feel like that's a pretty comprehensive coverage.
I'm assuming we took that language from somewhere. What cultural diversity?
Psych board. That's what we developed at Psych board a long time ago.
Okay, E. I don't have any questions or comments about E. Can you scroll down to F, Sarah?
I'm gonna, now that I've read this one more time, I think it would be clearer if placed here.
Yes, I agree.
Yeah.
Sorry, something like that.
Yeah.
Ready for F?
Yes, ready for F. I feel pretty good about this list under F. Okay. Let's move on to G. I like the one-to-one. Any comments there? Okay. Let's move on to H. I do have an issue with H1. I do want that supervisors continue to be required to take the jurisprudence exam. So I like Daryl's suggestion of moving H1 to B to maintain that requirement.
Agreed.
Do you want it, just limited to supervisors? That's how it is now. And if we move that wording like it is just there, it would apply to everybody. And I don't think that's what y'all are wanting. You're just wanting
No.
supervisors to have to take it, right?
Mm-hmm.
Okay.
Or at least that's my opinion.
I would not be opposed to everybody having to take it for their licensure renewal just to stay abreast of the rules, but I think it's very fair to keep it just for supervisors the way we had it before.
I'm in agreement with Dr. Elder. I love the fact if everybody takes it just to keep it fresh and to keep relevant. I think that's part of protecting the citizens of Texas.
My only hesitancy about requiring it for all licensees is that then there's a cost for it. And so if the jurisprudence exam was free, or if the jurisprudence exam was $10 or something, maybe it wouldn't be an issue, but I feel like we are then kind of almost like raising the, I don't know, anyways.
What is the cost of it, please, Dr. Merchant?
39.
Say that again, Dr. Elder.
I think it's 39.
I was gonna say, I think it's $40.
Correct. Yeah.
And what's the current rule on it? You don't have to take it again after you've initially.
Only supervisor.
You only have to take it if you're a supervisor.
I would be curious to see how many people take it anyway. I mean, I take it anyway every license renewal just because I want to know what it says and I want to stay abreast. So I'm wondering if the numbers that we see who take it actually reflect more licensees than are actually required to take it.
On the other hand, do we have medical doctors that take the medical exam every year? Do we have psychiatrists? Do we have clergy to take ordination every year? Do we have
Chaplain Stoglin, I think you have a really great point, but this is not a practice exam where they're having to recount all that they learned about how to do counseling. This is just a no-fail exam where they have to say, I know the rules.
I get it. We can do that, but I think the supervisor is good because they're supervising potential practitioners. I think we need to leave that alone. It's good. You once again, we keep adding layers, and then you're gonna have people say, you continuing education, we get that, but now you're saying just out of curiosity, well, how does it feel to jump out of a perfectly flying machine, the parachute? I mean, so how far do we go down? So I think the supervisor, I get it. The 6 hours, leave it alone for supervisors because they're bringing people potential into our field. I think that's good enough.
So question for the board members, if this is moved to B1, it means only the supervisors are required to take the jurisprudence exam, but it also means only the supervisors get credit for ethics for completing the jurisprudence exam. So if any other licensee takes the jurisprudence exam of their own volition, it would not be credited an hour as an ethics credit. Do I understand correctly?
That's the way it works right now, correct, Sarah? There's no rule that gives you credit for taking the juris if you're not a supervisor.
There is a rule that gives you credit. If you take the jurisprudence exam, it gives you some ethics credit.
Oh, does it?
Can
Okay.
can we leave this right here, passes the jurisprudence exam? You know, can we leave this here and then under B, under the special provisions, add that supervisors must take the jurisprudence exam? I mean,
Yes,
we just leave
you
this
could do
here and
that.
add that?
Yeah, you could do that.
Okay, let's do
Agreed.
that then.
Yeah. I like that idea.
So what are we adding?
So can we scroll back up to B and so that we can write some language regarding supervisors?
B3. B3.
Mhm.
I tell you what, let me pull up some language. We've already got this language, I think, for another board.
Right.
Let me see if I can find it real quick so that we're not having a wordsmith in the meeting here.
Yeah, or there also might be the language that's already an existing rule that we could draw from too.
Trying to imagine the reaction, say in a professional convention, if we were to give the board report and say, and now you all have to take the test every year. What do you think the feeling in the room would be on that? Thanks or what? That's onerous.
What? That's onerous.
I think so too. And I'm not sure that the benefit would outweigh the
Sarah,
or will.
Sarah, can you give me share screen real quick so I can show them what the LPC board, their rules committee has recommended? It's kind of the standardized language we're using. Okay, this is what is going to go before the LPC rules committee has greenlit this language right here. Nothing fancy to it. We just plug something like that. That'll be B3 for y'all.
So licensee with supervisory status must take the jurisprudence exam every renewal period.
Oh, I'm sorry. I was, yeah. I'm sorry. I don't know what I was thinking there. That's just the supervision. Yeah, we'll just plug that in. Let me stop sharing here.
Can we go back to your screen, Sarah?
Coming. So since it's about supervisory, those with supervisory status, I would recommend as number 2 rather than under 3,
Mm-hmm.
if that's all right with the board.
Yes, that makes sense. I think that's perfect.
Sarah, we need to say how much credit they get for it
Okay.
in there.
Do we need to, or because it says it down here, you know what I mean? Like, do we need to have it in both places, or since it's listed at the bottom?
I guess you'd be okay with it. I tell you what, we
Reference?
know what you're wanting. Let Patrick and I wordsmith it. We know what you're trying to do, and then we can send that on up. If y'all don't like it, if you don't like how we get it after the council publishes it, you can always change it because it won't be a substantive change.
Yeah.
So yeah, let us wordsmith it because I want to make sure we're syncing up with how the other boards are doing this. I want to get this as close to this, as close as
Got
the
our
same
heart on
across
it,
all
so we
boards.
know what we're trying to do.
Yeah, I know what you're wanting.
Agreed.
Okay, then we can just go back to, I don't remember what section we were on, H. Okay, so we just finished H1, H2. Do y'all have any comments? Let's look at H2, H3, H4. Any questions, comments about those? I feel good about them. Do y'all feel good about them?
Was good.
So let's talk about the self-study. I personally feel good about the 1 hour. It's 1 hour. I feel good about it. Any other objections or?
No, I like it. And I like that it's
Dr.
got its own
Merchant?
separate line item.
Mhm.
Because
I have a question about this one, actually. If the thought behind it is that everyone is doing reading naturally on their own in the course of their day or the course of their work, why do we even need to mention this, and why do we even need to? I'm not quite sure why we're talking about it, right? It's like we're saying, okay, you're going to get an hour for doing what you normally do. Why don't we just reduce the total hours by 1 hour and leave it alone and take it out?
You know, one thing that comes to my mind is all of these others can be quantified, but reading is difficult to quantify.
I think it incentivizes good behavior. I mean, we're making the assumption, but we also know there are people that won't. But it incentivizes the good behavior, and I don't have a problem with it.
And I concur with you, Dr. Skoma. The other is, Dr. Barti, it gives people an opportunity to read outside of the field that may be relevant to us and bring in new ideas and fresh ideas because they've read it. And if we could say, you know, list the self-study or something like that, I think that incentivizes people to enhance and enlarge our toolbox. Okay, because I know I'm a member of other organizations that are professional, and no, we don't take exams every year, because once you do it, and then, but they ask you to continue your education, including self-studies, because we have conferences, we have Zooms, now that Zoom is so popular, et cetera, and people come up with all kinds of ideas. Some of them are, I'm dealing with a chamber, economic development ideas, with hubs and MBEs and all of that. So historical underutilized businesses, minority business enterprises, and so forth. So it really enhances the opportunity to come up with new ideas and fresh perspectives and so forth.
It's 4 or 5.
For self-study purposes.
I do think it'll hopefully maybe encourage people who maybe aren't doing reading to read. So
Thinking about.
I don't know. That's kind of my thought, just that it might encourage people to read, or maybe, I don't know. I'd rather leave it at 30 and encourage that behavior. But I also, if, you know, I'm reading the comment that it was recommended by a plurality, but not a majority. So again, if depending on what we're going for, if we're going for complete consensus, then and I guess maybe I don't feel terribly strongly about it one way or the other, me personally. So I'm not going to like die on this hill. But if the majority of council members agree with it, then I'm cool with us having it here.
Dr. Merchant, I agree. I think it does incentivize good behavior. I can see the value of having it in, but I also am fine with it being taken out if that helps to standardize and meet the goals of the standardization work group. I'm fine either way.
I like the idea of self-study for reasons stated.
For the board's consideration, the social work board met on January 7th and approved this provision.
And I say we move forward. If it's going to be a part of, if the other boards are approving it, then I'm comfortable with it being in here.
I agree, Dr. Merchant.
Agreed.
So it sounds like we've made our changes to 801.261 requirements for.
Let's look at number 6 really quick. Oh, that's the human trafficking one. Okay. Yeah. Any other comment on these others? I, J? I think we're good.
Just for clarity, that maintaining proof of continuing education compliance, that's already in place, right? That's not a new.
I'm
Okay,
sorry,
so
Anthony, were you about to ask for a motion?
I was, in fact, I was going to ask, the language of the motion would be to submit this to whom? Just, I'm still with the BHEC process. To the council, to the BHEC. So would someone like to make a motion?
Yeah, I will. I'll make a motion that we submit this to the council for their approval with the changes that we've made.
Thank you. Seconded, Chaplain Scoggin, thank you. Questions, discussion? Have that. Those in favor of the motion? That is unanimous. Have we lost Mr. Francis? Okay.
Looks like it.
Before we move on, let me put something to the board. We've been at it for 2 hours. If you'd like to take a comfort break, also need to understand though that we will be, Dr. Elder, losing you in an hour. Is that correct?
In about 45 minutes, yes.
45 minutes. So would a 5-minute break be sufficient? Okay.
If we lose Dr. Elder, we don't have business complete. There
That's
goes the
what I'm
quorum.
worried with Dr. Francis not being here. I'm looking at quorum thinking. So
I expected Mr. Francis and Mr. Parrish to both attend. Mr. Francis was in and out. I'm not sure if he'll be returning.
okay.
I'm happy to plow through, but if we need a potty break, then
Mhm.
What's the mood?
5 minutes, come back.
5 minutes?
Oh, plow, okay, yeah.
Let's take a 5-minute break and then we'll come back and we'll push. It is 11:06, so we'll come back at 11:11. Make a wish.
Hey, can I mention one thing? Did you get all those things that were hanging up on the thing? I didn't need that other shirt. That other shirt. I know. Well, maybe we try. Too bad. Huge. Well, I looked up. This is a good travel and, but I looked up at semi-formal dress. Well, tomorrow.
looks like Mr. Francis.
That would be most fortuitous if Mr. Francis is here.
I've got connections back.
Excellent.
I went and stole my son's system, and so I'm piping through on his.
Will you be able to share with video when we go back?
I am connecting now.
Excellent.
Good.
Good.
No, Mr.
Well-
Francis, Mr. Francis, you didn't steal. The military term is you procured.
Well, technically, since I purchased it for him,
Yes, sir. And you temporarily acquired a needed asset for the mission.
he
We're
is
gonna go
not
ahead
going to be happy.
Officially reconvene. I'm going to ask Sarah if she'll take a roll.
So, Dr. Barty,
Present?
Dr. Elder,
President,
Dr. Merchant,
Present.
Mr. Francis,
Present.
Reverend Dr. Skoma,
Present.
Chaplain Stoglen. He's here, yes.
Here,
Thank you.
mute was not, my mouse was not cooperative. Sorry. All right.
With Mr. Francis back, we're okay, but just want to make sure everyone understands that we are, when we lose Dr. Elder, we only have one additional for quorum, so that if we lose anybody else, we could have problems. And we want to make sure that we have quorum for public comment and not disappoint the public on that. So we want to do all the business and do it right, but if we could move along at a pace, that would probably be best.
If we lose quorum, does the meeting end, or can we just not vote on anything?
The meeting ends,
Counselor?
I believe.
I don't think we can do anything.
You can't, yeah, you can't do anything
Okay, we can't.
other
discuss
than,
it.
other than I think move to adjourn. Yeah.
With that being understood, let's move to agenda item 16B, changes to 801.58, 801.143, and 801.305 related to technologically assisted services, supervisor requirements, and schedule of sanctions. Mr. Spinks, do you want to walk us through this again?
These are just the rule changes that are needed with the proposal of the continuing education rule. We need to make changes to these other rules.
Okay.
I can make a motion that we approve the changes, that we approve those changes.
second,
You might consider doing C as well, because C is a repeal of the existing rules that govern continuing education. So you could just do it all together.
So we can lump all of those together as one motion?
Yes, sir.
Okay.
I make a motion then that we approve the changes in B and C.
second,
Dr. Elder on the second. Okay. Let's open up for discussion and questions on this. You have them under 16B and C. It looks like there are 6 different documents. Any questions about these? Okay, seeing none, I'll call for a vote on accepting these. And I guess we would be, I'll just, I see, let's do
unanimous.
hands again. I'm sorry, I was confused. And so it's unanimous.
Surprise.
That happened fast. You got to be on your game. All right, agenda item number 17. A report from the board chair concerning current challenges, accomplishments, lawsuits, interaction with stakeholders, state officials and staff, committee appointments, functions, workload of board members, conferences, general information regarding the routine functioning of the board. I'm going to throw this to Chair Merchant.
I really don't have much to say. I'm really pleased to see that pretty much all the committees met this last quarter, and y'all did some really good work. I just really appreciate all the things that the committees are doing. I don't know that we'll have time to discuss this, so I'm gonna probably not say much about it, but I do really want us to be meeting in person in some way, some form, some format. And so perhaps I'll have a conversation with Director Spinks about how to make that happen. I think that it's something that we're all eager for us to be back in person. Is my sense of that correct, or maybe not so much?
I'm fine with meetings by Zoom, but I'll do whatever the board feels is best.
I greatly miss being in person, and I do think it affects my ability to connect with the board, especially new board members. And so I just, as quickly as we can get back to in person, I would be in favor of that.
I'm worried about maybe some of the involvement of some of our newer board members. And I think that part of maybe sometimes the lack of presence is because we are not meeting in person and we don't have the ability to form these connections and relationships. And so I don't know, I would love to see us meeting in person again for both committee meetings the day before if possible, or the morning of, or something along those lines, as well as then meeting in person for our board meetings. Anyways, so perhaps I will brainstorm with Director Spinks about how to make that happen, if the board is in agreement.
Good.
Okay.
Okay.
Okay, that's it. That's my board report. So we can move on.
Thank you. Oh, we said we're gonna work fast. We hit it.
Oh, Mr. Francis.
The only thing I would ask is if we meet in person, is if we have a room large enough that we can safely space. So I know that our traditional room that we've met in, we're very close to each other in proximity, and that would make me kind of nervous personally. And so I know, like everybody else here, we just want to keep healthy. We all have families and priorities that we have to take care of. So I would just ask that we have an appropriate space placed. If we do that, that would be my request. Thank you.
It's my understanding Mr. Spinks is working with another board to try to find those spaces as well. So if that works, that could work for us.
Yeah, I certainly understand the desire to meet back in person. I'm hearing that across the spectrum from council and the boards. I'll tell you, one of the things we struggle with is some of you may want to continue coming in via Zoom, either that's just your personal preference or your schedule may dictate that. A lot of the facilities, it's easy to broadcast out. Like if I get you a room over at the Capitol right now, they're not in session, so you can get rooms there where I think we can broadcast out pretty easy, but I can't have anybody Zoom in and we can't take public comment virtually. Those are the issues that I struggle with there. And then of course, as we shift over to using the recordings in lieu of meeting minutes, I got to make sure that we've got a good recording that we can then post to YouTube and retain. So those are just some of the logistical things that we have to deal with. But I think it's doable. I think Chair Merchant, you and I can get together, but I think it's doable to start looking at, if nothing else, some hybrid style meetings where we can get those who want to attend in person, and those who need to come in by Zoom, they can Zoom in.
Thank you.
Thank you, Chair Merchant. That takes us to agenda item number 18, a report from the board delegates to BHEC regarding activities of Executive Council. We don't have Ms. Smith with us.
Mr. Francis
Mr.
is
Francis,
the
would
public
you-
member, and
Yeah.
Your meeting materials included written reports from the council's last meeting and other rulemaking acts.
And I would rely on that. As I said before, please forgive me. I just don't have any notes or my computer with me today.
I can field any questions the board members may have about the rulemaking process, but I did provide you a summary.
Any questions on this summary?
Daryl, do you have any update regarding agency-related travel and the budget? Is the council continuing to look at that at their next meeting?
Well, the committee that they've put together is still working on that.
Okay, thank you.
Everyone satisfied with the BHEC process? Okay, we'll move along then to agenda item number 19, a report from the board administrator, and I will turn it over to Ms. Fassholz for that report.
So I'll be brief and just ask that people visit our website. Know that there's, from the homepage, there's agency news. We have an upcoming Insights Over the Lunch Hour, which was well attended in October. If you'd like to receive notices from the council or from the social work board, complete the email update and follow the subscription things. Please be aware that there's information about the fingerprinting process, which is required for renewal. We're continuing to have some people having some difficulty with their renewal because they are either not understanding that process or weren't aware that it's a required process by statute. So look into your renewal early and rely on that page to instruct you on how to do that. Unless there's any questions from the board, I'll conclude my report there.
Ms. Fastfold, a helpful item might be when we have the meetings virtually, if we happen to have any new people attending to view these, if we could post the website in the chat window here so they have access. If they just aren't familiar with it, it just might be a little bit step getting them closer.
I'll look into it. Thanks.
I just want to say that I love that y'all are doing the like the little lunch and learn things. I think that is excellent way to connect with our licensees, and I'm just thrilled that y'all are doing that. So thank you.
You know, we can do that with board members too.
I would be
Hint,
more than happy to do it. I would do it. I would do it in a heartbeat. Like
Being down, I was wondering, could I drop in on one of those? I'd like to learn a few things.
Yeah. But I mean, if the board members want to have a virtual
I would do it.
virtual presentation, Sarah can hook you up. And
Yeah, I mean, I've done it for TAMFT. You know, I've done a couple of different presentations with TAMFT. So if y'all wanted to sponsor one, sign me up. Tell me when. I'll be there.
I think it's a good idea if board members do it. I'll just say that.
I think it's a good idea too.
Daryl, is this a good time? You remember our discussion about the CEUs? You remember that?
Oh, yeah.
Yes. If you want to bring that up now.
Sure.
Okay.
Chaplain Stoglin had called me a while back and was wondering if like our insights over the lunch hour type stuff, if that would count as continuing education. I'm like, I never even really thought of that. I don't know why it wouldn't. I guess I kind of need to know from y'all take y'all's temperatures, since CE is kind of an area that y'all, I mean, obviously y'all got a say in that, but what do y'all think about the agency giving credit, you know, like an hour credit for attending those seminars? I'm going to ask the council how they feel about it at the next go around. But I mean, if y'all are like, no, we don't want that, you know, then okay.
Would it create a burden on staff? I mean, I'm just thinking about in terms of how would somebody prove it? Would y'all have to issue?
Well, I can set
You
Zoom to
certificate?
where it'll kick out an automatic email to folks who attend, and I can put some text in there just saying, okay, keep this. This is proof of 1 hour CE credit.
I'm in favor.
Would it be an ethics type of credit or?
I would think so, because I mean, that's about all I'm qualified to talk about. But
that was my initial reaction of, well, what kind of credit would we give? And, you know, I know it talks a lot about the logistics of applications and fingerprinting, and that is Texas rule in my mind.
Yeah.
So that would certainly be an ethics credit.
Absolutely.
Since half of these credits we were saying basically come from anywhere, do we have to do anything in rule or statute? Or can you just advertise it that way? Hey, by the way, you can count this hour towards.
well, I have to comply with y'all's existing rules. The way I wrote this other rule, the way that the standardization committee wrote it,
Okay.
yes, anything put on by the agency will count as continuing education.
But
It's really not expressly laid out in your existing rules. So I have to be real careful. I have to kind of do a little extra legwork to make it count. So, but I didn't want to do it until I read it by y'all.
Advertising the luncheons that way.
Okay. Well, the folks that have already signed up, they'll just get a surprise email. They'll get an hour. But going forward, we can advertise it as such.
Yeah, and just be sure you put the word ethics in there on that email. So that'll calm their fears.
Yeah.
How do I do?
Thank you for that idea, Chaplain Stoglin. It's an excellent idea. So, and thank you, Executive Director Spinks, for being open to it. So.
You're welcome, Dr. Merchant. And thank you, Daryl, for that.
Board Administrator, have anything else on the report?
That concludes my report.
Thank you very much for your report. Excellent work. We are in good hands. Agenda item 20 is discussion and possible action regarding future priorities and activities of the board. We have discussed future meetings. I guess we should mention the next meeting will be April
29th.
29th.
Yes, April 29th.
April 29th. And as of this moment, it'll be like this, but that could change. Is that what I'm saying?
Yeah.
Everything could change. Anyone have any other items about future parties and activities? Marching? Okay. Well, let's go ahead and open up for public comment. We'll open the floor now, and we'll ask the board administrator to walk us through the process. And remind you, we can't really offer discussion on these points, but if something's brought up, we can schedule it for future meetings.
Thank you. So we have no one attending here in person, so we'll start with those that are attending by computer. If you wish to give public comment, please use the raise hand feature in your Zoom meeting now. It generally is on this lower toolbar. All public comment is limited to 3 minutes unless otherwise designated by the presiding officer. Please identify yourself and whether you are speaking individually on behalf of an organization. Please do not make any public comment regarding a licensing issue or open complaint. We have other venues for troubleshooting those areas. So I'm looking up and I don't see any raised hands among the attendees. And I have no one who appears to be attending by phone. So I believe that concludes public comment, there being none. Oh, I do have a raised hand. Ms. Martin, you have public comment?
Only a gratitude for your service at this point in time, and a look at the standardized suggestions for standardized CEs. I think we'll have to step up the game a little bit, which is not a bad thing, because in the Rules Committee yesterday, our representative, and I think all the other representatives for the LPC Rules Committee were for not lowering our standards. So I just want to thank you that you're with your standardization with the CEs. It looks like we're going to have to step up our standards, step up our game a little bit, and that is a challenge for us, and we need that challenge. So thank you for your hard work. And again, Chaplain, thank you for always reminding us of the great state of Texas. Thank you. I represent Christian Counselors of Texas, by the way. Thank you.
Thank you.
Would anyone else have public comment? Use the raised hand feature at the bottom of your screen. Seeing none, that concludes public comment.
Thank you. Agenda item number 22, are there any announcements or comments not requiring board action from anyone?
I can announce that February 1st is the council's meeting. February 10th through the 12th is Christian Counselors of Texas Conference in Pflugerville. February 28th is our next Insights over the lunch hour. That's where you can Zoom meet with Director Spinks and the board administrators for each of the member boards. April 7th through 9th is TAMFT in Fort Worth. Dr. Merchant will be presenting a session. April 29th is the next Marriage and Family Therapy Board meeting. May 18th is the following council meeting, and I'll stop there.
Mr. Chair. Excuse me. Mr. Chair, I just want to say that we all are aware of what happened in the Metroplex about a week ago with the hostage situations. Mental health professionals were called. The FBI and all of those were involved in a very dangerous situation, and people of faith got together and helped. I was in Abilene, Texas for the MLK weekend and received calls, and one of the families in particular was only 3 blocks away from the incident and did not have to evacuate, but they kept us informed. Called on several communities of faith to pray. They did. The great state of Texas responded accordingly. And Mr. Chair, I just want to say that this state, with all of our challenges and issues at times, come together when it is critical. And last weekend demonstrated our tenacity and our people of faith and our mental health community. And I want to compliment them for doing that because it proved that what we are doing as a board are definitely protecting the citizens of the great state of Texas. And finally, I want to thank publicly Dr. Merchant for being approved for tenure at her university, and a job well done. With that, I'll yield.
Thank you, Chaplain Stoglin. I appreciate just a reminder about these things that have happened this weekend and the importance of our work. And I appreciate your appreciation. So,
Dr. Scoma, there's one issue I wanted to bring up. I don't want to pick at a scab here or anything, but that back on those guidelines for the technology assisted, I know those are going back to Rules Committee, but I got to thinking about it. And I feel bad. Y'all could, if you wanted to, you could go ahead and adopt those now for publication, just minus that one sentence, and then just kick that back to Rules Committee. If y'all want something out there right now, you know, I know it was tabled and sent back to Rules Committee, but I guess what I was saying is if that was the only thing holding it up, if y'all wanted to go ahead and get something published out there now, you could publish it without that sentence and let the Rules Committee do their thing with it. And if they make, it's easy to change because this doesn't go to the council for anything. It's just whatever y'all vote on is how the guidelines are published to the website. So I just wanted to throw that out there in case y'all wanted to. I didn't want to leave you with the impression that it was, you got to table it. You can't do anything right now.
I understood that at the time.
Okay.
But I'll open it up if you want to.
Mr. Francis.
I just want to say first, thank you, Director Spinks, for bringing that up. I do appreciate the acknowledgement of it and the other possibilities of it. And the more that I was sitting here thinking about it, I do think it was just that one line that was causing the whole issue to get tabled and come back. And so what I would like to do is to make a motion that we bring it back to the board, that we open it up again now, and we accept it as it is with the exception of that one section to go back to the Rules Committee and publish the rest.
I second that motion.
When you say as is, George, you mean with those other reordering changes?
Correct.
Okay, gotcha.
Why don't we pull the document back up? Let's do it correctly. I'm sorry, I've heard a second.
I seconded.
Okay, so let's open it up for discussion. And in doing so, let's just clarify what we're doing. Could somebody remind me the point number?
It's the very last point about avoiding social media contact. So basically what Mr. Francis is proposing is that we publish the document with the changes, with the reordering, it's striking that last line and then letting the Rules Committee reconvene and discuss if they feel like that line is necessary or if they are okay with it being struck.
Where are you? Here we go. Okay. Draft guidelines for using social media. So again, we flipped.
So the
Sarah, you just
first,
want to walk us through what we changed.
the first bullet item will be maintain appropriate professional boundaries. Sorry, it splits on the page, so I can't show them all at one
That's
time.
okay.
But that's the first bullet item would be maintain appropriate professional boundaries with clients and their surrogates, whether online or in person. The second bullet point would be use separate professional and personal web pages and profiles for social media to clearly distinguish between the two kinds of virtual presence, etc. The third bullet point would be politely turn down requests from clients to connect on personal social media networking sites, etc. The fourth bullet point will be ensure the proper informed consent is conducted prior to engaging in social media with clients. And then the other bullet points were to follow.
And so then the
And
motion would be to remove, avoid viewing your client's presence, just to strike that.
Well, to kick it back to the committee.
The Rules
So
Committee.
we would go ahead and publish this without that last line And then the committee in their next meeting would discuss again whether to add this back in or to leave it struck out.
But for right now, we're just
It would
gonna,
be right now it would be published without that last line.
so that's what's on the table. Thanks for the clarity. Anyone else like to discuss before we put it to a vote? Okay, those in favor, by show of hands. Looks like that passes enough unanimously.
Thank you again, Doctor. Thank you again, Director Spinks, for that. Appreciate that.
Yeah, we'll get that on the website by this afternoon. So that'll be up there today.
Great.
Okay.
That's good information. So that's the right thing. Okay. As a reminder that I am merely keeping her seat warm, I want to throw the penultimate word to Dr. Merchant if she has anything for us.
I don't think so. I appreciate all of y'all's work. Dr. Elder, I especially appreciate you rearranging your class schedule and everything to be here. That just kind of shows your dedication. As always, I just appreciate all of y'all taking the time to pour yourselves into this work. It is meaningful, and you don't have to be here, and yet you are. And so I just appreciate every single one of you for your time and your attention. So thank you. And especially to you also, Reverend Dr. Skoma, for taking my seat, because I really did not want to have to get up at 4 o'clock in the morning and fly down this morning and then turn around and fly right home. So thank you.
Anytime. Again, 18 minutes from my house. So we're anytime I can help. All right. Well, with that said, it is 11:38 on Friday morning, January 21st, 2022. Would anyone like to make a motion to adjourn this meeting?
Mr. Chair, I move, and may God bless the great state of Texas.
All right.
I'll
Thank
second.
you. Discussion? Those in favor? All right. Motion passes. Thank you all very much. Thank you to the staff, and God bless Texas.
Thank you.